But again, most of this stuff is not covered by the text. All right, so I guess for you all, you're here, so that's good. But most of it's not covered by the text. But we'll get into it, and as we get into it, if you got some questions, feel free to ask. I know the Cardinals are playing. I know the Yankees are going to be playing. Let's see, who's the Titans?
Texans are playing tonight. I don't know who they're playing.
Or the Texans and who?
Jets.
Okay, so yeah, Texans and Jets. I mean, I got a lot to compete with here. But hey, what's more important? The Cardinals, the Yankees, the Texans and Jets, or the Fair Labor Standards Act?
I don't know. If the Cardinals make it to the World Series, we might have to talk.
Yeah. All right. So, all right. With that in mind, let's get started. We'll see where we go. We'll see how far we get and run from there. What we are going to talk about starting tonight and cover over the next class period or two is this idea of the Fair Labor Standards Act, the workers' compensation. We'll look at some workers' compensation, some basics of it, and unemployment laws and things of that nature. So as we get into that and as we get ready to look at that, let me ask you this. What is the Fair Labor Standards Act? I mean, why do we study it? Anybody got any idea? Day, we'll just ask Day. Hi, Day.
Hello.
Any idea what the Fair Labor Standards Act is? I'll just put you on the spot because none of your classmates want to volunteer. They all pointed to you, so
Okay.
that was nice of them, right?
Fair Labor Act.
Yeah, the Fair Labor Standards Act. Any idea what it is at all? What it's?
To provide equal, I don't know.
Okay, well, no, actually, that's one part of it. That's the one part we probably won't cover tonight. But one part of the Fair Labor Standards Act is to provide equal pay for equal work. All right, Day was right there. I mean, right there. But we're going to put that part of it off because it's a sexual discrimination, and we're going to really cover that part of the Fair Labor Standards Act when we cover sexual discrimination. All right, and gender discrimination. So we'll talk about that act. We'll parse that portion of the act out. What else? I mean, any other ideas what it might be? Fair Labor Standards Act. Jackie?
Does that include minimum wage?
That's exactly what we're going to be talking about tonight. The basic part of the Fair Labor Standards Act, the basic gist of it, other than this sexual harassment component, which Dave told us about, is this idea of minimum wage. All right? Now, it is a law that has been around for a long time. The Fair Labor Standards Act has been around since 1938. All right? Since 1938. It's a federal law, not just a state law, but a federal law. And it basically provides requirements and guidance, if you will, for minimum wage, for overtime pay. It provides some child labor guidance and regulations, which we'll look at very briefly. And then it provides, which we're not going to look at in this particular unit, but we will look at in a few weeks, is this whole idea of equal pay for equal work. Okay? So minimum wage, overtime pay, child labor, and also equal time for equal work. So it has a sexual discrimination or a gender discrimination component to it. We're just going to put that part of it off for a few weeks. Basically, the Fair Labor Standards Act looks at covered entities based on two ideas. One is what we call enterprise coverage. In other words, it applies to employers who meet an enterprise coverage test. All right? And basically, the enterprise coverage test says that if an enterprise, or a particular business, if you will, that's the term we're going to use, enterprise, is covered, then all of the employees within that enterprise are also covered. Okay, so that's one test. You have an enterprise coverage test, and we'll get into that in a little bit more detail. The enterprise coverage test basically says, hey, if the enterprise itself is covered, then all employees within that enterprise are covered. The second coverage test, if you will, is what we call an individual coverage test. So that even if the enterprise itself is not covered, there may be particular employees within that enterprise that are covered. All right, we'll come back and talk about that. But basically, here's really what you need to know. Almost everyone is going to be employed or governed by the Fair Labor Standards Act. Now, a couple of things on that enterprise coverage. Basically applies, it's a twofold prong or two-prong test on the enterprise coverage. Basically it applies if you have an enterprise that has at least 2 employees. All right? You have an enterprise that has at least 2 employees and at least $500,000 a year in business. All right? So if you have at least 2 employees, or at least 5, and make that an and at least $500,000 in business, you're going to be covered by the Fair Labor Standards Act.
That's a year, right? 500,000.
That's a year. Yeah, good question, Tom. That's a year. All right. So I suppose you could have, and let me just give something off the top of my head that I can relate to, is you can have a lawyer in private practice, just one lawyer, and he makes $400,000 a year. All right. Probably doesn't have to comply with the minimum wage law. Now, will he? Jackie, you shake your head yes. Why?
Well, it's really the only way to get good employees.
Yeah, Jackie says it's the only way to get good employees, and you're absolutely right. Whether he has to be required or whether she, as a lawyer, may have to be required to cover or to pay minimum wage under the Act, they're going to do it anyway because they're going to have to in order to get good employees. But the enterprise coverage test basically says, hey, if you've got 2 employees and you make $500,000 a year or more, okay, you're probably going to have to be covered. Now, there's some little exceptions to that. We're not going to get into that, but that's the gist of it. Individual coverage says there are other things that that particular individuals are covered regardless, and we're not going to get into those exceptions. There aren't a lot of them, but there are a lot of manual labor employees have to be covered. But again, we'll leave that and just talk about the enterprise coverage. And that's really where we're going to focus. Now, the basic gist of the Fair Labor Standards Act, if you will, is to pay minimum wage. All right, that's one of the basic guidelines of the Fair Labor Standards Act. Here's the question: why do we have minimum wage? I mean, remember, this whole employment law class, anyway, is all about conflict, right? It's a conflict between employers, conflict between employees. So why do we bother worrying about having a law that addresses minimum wage? Why do we have it? Jackie.
Given the context of like the early, 1900s, I think it has a lot to do with the fact that people needed work, but they had employers who were kind of forcing them into taking lower and lower wages, and so like people couldn't live off what they were making, and the government wanted to help out with that.
Yeah. No, I think that's exactly where it comes in. As Jackie says, and you remember the time frame when this act came into place. It came into play when?
1938.
Yeah, Right. It comes into play in 1938. So as Jackie says, you've got really the government stepping in because there are people who need to work. There are people who are available to work. And by the way, you've got more and more employers emerging. So they need people to work, but if they can pay them a paltry amount, then they will. The government says, no, you got to come in and we're going to require you to pay what is minimum wage. All right. Now, minimum wage, a good thing or a bad thing? It's a good thing for the employee. All right. It's a good thing for the employee. Why, Tom? I mean, and we know the obvious reason, but.
Because it gives them a fair chance to make more money than what the employer is willing to pay.
Okay.
Going from an economic standpoint, because you have a supply and demand, and you have the equilibrium. But if you set a minimum wage that's higher than the equilibrium, you're going to have more people wanting jobs, so you have a better chance of finding people willing to work.
Okay.
But there's going to be less people employed.
Right. It all comes down to this whole concept of, yeah, is it a good thing for the employee? Sure it is. And there is an equilibrium there. There is a balancing test there. At some point, the minimum wage, if you didn't have it, employers would still have to pay a so-called minimum wage. For what reason?
It's going to be an equilibrium price, basically.
Yeah, just to compete.
Yeah.
All right. If I'm an employer, let's say there's no minimum wage law at all, and if I'm an employer and and I need people to work, and there are other employers that need people to work, at some point we're going to reach, as Tom says, an equilibrium where we know what that minimum wage is going to be. Now, right now it's said it's based on a lot of different records. By the way, here as we stand in 2012, what is the minimum wage? Yeah, $7.25. Okay, $7.25. Now, that's under the federal law. There may be particular states, I'm not aware of any, but there may be particular states that have higher minimum wage. All right, keep in mind the Fair Labor Standards Act is a floor. When we say it's a floor, it is a federal law that requires employers to pay a minimum of $7.25. Some states have different minimum wage law requirements. And if a state has one that is higher than the federal law doesn't preempt that. So if you work in a state where, let's say, it's $7.45, then you got to pay $7.45. And I'm not aware of any right off the top of my head that require more than what the floor is set by the federal government. But if there were a state out there that required it, you would certainly have to pay that. There is minor, we'll talk about some exceptions to that, but one of those exceptions is what we call a youth wage rate. Okay? And there is, an employer could pay $4.25 per hour to new hires younger than 20 for the first 90 days after they're employed. Now, most employers don't pay that. Let me give you that again. There is a younger, higher rate. So if you're an employer and you hire younger people under the age of 20, and we'll talk about child labor in a little bit tonight, but if you're an employer and you hire somebody under the age of 20, you can actually pay them $4.25 for the first 90 days of their employment. All right? Now, most employers don't do that. Why?
Because they probably quit.
One, they'd either quit or they wouldn't get them there in the first place. And why is that, Tom?
Because people know the minimum wage is $7.25. They're not going to want to work for $4.25 an hour.
Right, and they can go somewhere else that will pay them. What else? Why else as an employer may you not want to pay the $4.25 for 90 days, even if you could?
Disgruntled workers.
Okay. Yeah, you may have disgruntled workers. What else? Any other reason? From practical standpoint, it would just be horrible to administer because you have to do it on an individual basis. It's not like it's $4.25 for every employee under 20. It's $4.25 for every employee that has just been in your employment for 90 days. Okay? So if somebody comes on, particularly the industries that would pay it are going to be what? Where would you see that paid more than anything?
Retail, fast food.
Retail, fast food. And what happens? What's your turnover rate in retail and fast food?
Very high.
It's extremely high, okay? And when you have high turnover rate, now, every time somebody comes in, you got to start the clock again. It's just easier to pay people $7.25. And so while you can get by with or $4.20 or pay some people $7.25, even though you could get by with $4.25 for an individual basis. Now, with regard to the minimum wage, what makes up minimum wage? Cash, all right? But there are other things you can get credit for, other things besides cash. So in determining whether or not you've paid somebody that $7.25, you can also include other things such as food. Tom?
Tips.
Tips, all right? And we'll talk about tips in just a second, okay? Tips, food, certain benefits. Health benefits are not one of those, okay? But certain benefits, okay? Reasonable cost of room and board can be considered in there. All right. Now, let's go back. Tom talks about tips. Waitresses get tips. If a waitress averages tips of $5.13 an hour, then the employer can pay, $5.12 an hour, then the employer can pay $2.13 an hour. It's got to match up to $7.25, all right? But an employer can pay an hourly wage to a tipped employee that is as low as $2.13 an hour, so long as the tips make up the difference to get you to the $7.25. Okay. Do we have anybody who's served as a worked as a waitress lately? Yeah, Anna. And what, if you don't mind, what were they paying?
I mean, what do you mean, an hour?
Were they paying minimum wage and allowing you to keep all your tips, or were they paying less than minimum wage?
You get to keep all your tips.
Okay. And were they paying you minimum wage?
No.
Okay.
It's like 4 or something.
Okay. Yeah. It's all going to depend. And the burden is upon the employer to prove that minimum wage is being paid, which is a pretty hard burden. So they have to just show what average tips are. And they can do that through various means. Okay. But generally, you can pay less to tipped employers so long as their tips equal or bring them up to that minimum wage. Okay. Now, what can you deduct? Well, deductions from pay are illegal if they drop you below that minimum wage. For instance, Anna, let's go back to you. Did you have uniform? Did you have to wear a uniform?
Kind of.
All right. Did you have to pay for it, or they provide it to you?
They provided it.
Okay. Many employers will provide you a uniform. If, however, an employer may charge you for the price of that uniform, okay? That price of that uniform, however, cannot go below minimum wage, or they have to make it up to you. All right? Does that make sense? So if minimum wage is $7.25 an hour, and you work, I don't know, whatever gets you to a nice round number, let's say $300 a week, all right? And that's the number of hours at $7.25 that gets you into $300. I've not done the math on this specifically, but it gets you to $300, and that would be the minimum wage. If you drop below that by the uniform, then the employer has to still pay you that increase to make sure that you get the minimum wage. Okay. All right. Any questions on that? You can deduct as long as you don't deduct below minimum wage. Jackie?
Was 213 like the set number, or was that just your example number?
No, 213 is a set number. 213 is a floor. Okay, they have to be paid a minimum of 213. Yeah, sometimes that's a good question, because sometimes I just make up numbers, right? That one I didn't make up. That's a real number. 213 is a floor. Okay. All right. Now, some of the issues that you get into on this whole idea of minimum wage is, well, what is work? All right. What is work? And when is it? You get into issues of time that is suffered versus time that is permitted. Okay. Well, I'll tell you what. Let me list these for you, and then we'll get back and go back over them. Suffered. When we're talking about work, we're talking about suffered or permitted. Okay. We'll talk about waiting time. On-call time. Meal and rest periods. Training time. Travel time. And the last one is sleep time. Okay. So when we talk about suffered or permitted, work that is not requested but is suffered or permitted is work time. Give you an example, all right? I used to work fast food, all right? Worked at Dairy Queen. Now, when I was working there, it works the same way as most fast food restaurants, most waitress positions. They put up a schedule and they say these are the hours that you're going to work, all right? And you may work so many hours on Tuesday, Wednesday, and Thursday, be off Friday, work so many hours on Saturday, whatever the schedule is, okay? Now let's say my schedule is Tuesday, Wednesday, Thursday, I'm off Friday, and I work Saturday, all right? And I show up on Tuesday because I'm a dedicated employee. I show up on Tuesday, Wednesday, Thursday, and I show up on Saturday. But I'm going, you know what? I'm not supposed to work on Friday, but I need a little extra money. Christmas is coming along, so I'm going to show up on Friday, all right? Now, nobody's asked me to come to work on Friday, but gosh, I love working at Dairy Queen, right? And so I show up on Friday because I like making the little curl on the little cone and dropping the fries in the basket of grease, right? And like smelling like grease, right? Okay. If they allow me and they say, hey, you're not supposed to work here on Friday, and I go, I know, but I love this job. Let me do it. If they allow me to work, do they have to pay me minimum wage? Yeah, they do. Because even though they didn't request it, I suffered the work, or they permitted it by not saying, get your rear home, or whatever else they might say. Okay? So that's suffered or permitted time. Even if it's not requested, if they allow me to work. Then we have waiting time. Waiting time is usually counted as worked time when the employee is unable to effectively use his work or time for his own purpose.
Can you repeat that?
Yeah. Waiting time is usually counted as hours worked. So waiting time is usually counted as hours worked when the employee is unable to use the time effectively for his own purpose. Give you an example. Let's go back to our Dairy Queen or our waitress job, okay? We've got somebody working as a waitress in a restaurant. Her hours or his hours were, say, noon to 8 o'clock at night, all right? Things died down at 8 o'clock. Even though the restaurant's open till 10, things died down. And so let's say that the employer looks, Anna, I'll just pick on you because you've mentioned you've waitressed some. Let's say our employer goes to Anna and says, all right, I know it's 8 o'clock. I know you get off at 8, and I want you to go ahead and clock out. But the Bears are just getting ready to finish a game, and I don't know if they're going to come over to our restaurant after the game or not. So hang around for the next hour, and if they don't, have a drink, do whatever, but don't work. But if they show up in the next hour, I may clock you back in. At that point, does she get paid minimum wage for that period of time? Not disregard the facts with regard to what the amount of minimum wage is, all right? But does she get paid? Melissa? Why?
Because you've asked her to wait, she can't leave.
She can't do anything with that hour. I mean, it's probably more clear if I say 15 minutes. I still have to pay her that 15 minutes. Now, it's less clear if I say, I'll tell you what, Anna, why don't you go run, do whatever you want, but stay close by or stay on your phone so that I can get you back here in 10 hours, okay, sometime during the 10 hours. That's going to be less clear issue because then she may be able to do what she wants. If she's completely relieved from duty or he is completely relieved from duty, it is not work time. Or if they can use it for their own purposes, it's not work time. But if an employee can't use waiting time for their own purposes, then it is in fact going to be counted as work time, which means they got to be paid minimum wage, okay? Similar to that is on-call time. And on-call time is hours worked when the employee has to stay on the employer's premises or so close to the premises that, again, they can't use the time effectively for their own purposes. Okay? So it's a lot like waiting time. If, on the other hand, I give my employee a pager and say, hey, you got your pager. I don't know if we're going to need you or not. Turn your pager on, but go do whatever you want for the next 5 hours, and I'll call you if I need you, and I hope you can get back here, and I want you to get back here. At that point, it is not going to be work time. Okay? So it's all about whether or not they can use it for their own purposes. Okay? Now, mealtime is generally not hours worked as long as the employee is relieved of their duties. Okay? Mealtime is generally not worked or not hours worked if the employee is relieved of their duties. Okay? So let's say I work at a place that allows an hour off for lunch. All right? And our employees clock out when they take their hour off for lunch. All right? So I have a particular employee that does what they're supposed to. They clock out when they go to lunch for an hour, but during that hour, they get their lunch, they eat at their desk, and they work. Do I have to pay a minimum wage? They, yes.
They're working for you.
They're working for me, okay? Yeah, and if nothing else, we get back to that suffered or permitted. I may not have requested them to do it, but I know they're doing it, and then I have to pay them. Now, if I don't know they're doing it, that may be a different issue, all right? That may be a different issue. But the law's not going to, or the courts aren't going to let me get by with that very long, because at some point I got to know what my employees are doing. And so how do you handle that employee who insists on working during their lunch hour? Melissa?
Tell them to use like the break room or.
Yeah, tell them to use the break room. Don't take work with you. And I'm the employer, and I don't want you working during this period of time. And sometimes you have to do that. Why may an employer not want them working, particularly an hourly wage employee? Why may an employer not want an hourly wage employee working through lunch? Overtime. All right? And if you don't squelch overtime, then you're going to be responsible for it. Okay? And so meals are not hours worked when they're relieved of their duty, but if they do work during that period of time, then they may be entitled to minimum wage. All right? Training time, still one, we don't see a lot of the issues with this suffered, permitted, waiting time, on-call time. We don't see a lot of that. We still see some employers who don't have the handle yet on training time. Training time is generally compensable time. All right? Generally, it is compensable time. The only time that it is not compensable, training is not compensable when, and all of these factors have to be in play. The attendance is outside the regular working hours. So it's outside regular working hours. The attendance is voluntary. That's really the key right there. Attendance is voluntary. And the employee does not perform any productive work during the attendance. And then this one as well, the training or the meeting has to be over something that's not job related. Okay? So it has to be voluntary, has to be outside regular work time. The employee can't be doing any work, and the lecture or the meeting cannot be job related. Now, give me an example where you might have those situations occur. Just make it up.
How to prevent or establish an emergency kit for your home.
Okay. Yeah. We might talk about certain things that just benefit the employees for themselves on their own time. Some kit or something for their home. Okay. If I'm working in the food industry, I cannot talk about training. I cannot train salespeople and say they don't have to get paid for it. Okay? You're not going to see that very, very often, but that's when training time does not have to be paid. Yeah, Jackie?
Would that include like sensitivity training? Is that still considered job related?
You know, I think sensitivity training is going to be required to be paid because why does an employer give sensitivity training?
To avoid liability?
To avoid liability. It's all about the employer, okay? Now, you can take that, if you take that test, you could eventually get back to an employer benefit for anything, all right? But sensitivity training, most people aren't just going to say, I want sensitivity training because that's what I want to do on my spare time, you know? Now, I think if you offered a CPR class, because I think that's a little bit different. The idea behind sensitivity training is if you don't get it, you're certainly going to be liable and it comes up all the time. I think an employer can offer a CPR class in most businesses, not a hospital, but in most businesses, if it's voluntary, probably would not be required. Okay? You could still make the argument that CPR training would benefit the employer, but in that case, it's a further, it's harder to get to. All right? And so I think you're probably okay in that particular case. All right. Travel time, ordinarily the time to and from work is not covered. Okay. Ordinarily the time to and from work is not going to be covered. Travel, however, between job sites is going to be time that is going to be covered. In other words, your employer generally that has multiple locations, generally can't say, okay, I want you to clock out at this McDonald's, take this bag of fries over to the McDonald's across town, and then when you get back, clock in. No. If they're doing that work, they're going to be paid for it. Okay? Going to get minimum wage. All right. Sleep time. Generally, not always, but generally if an employee is on duty for less than 24 hours, that employee is considered to be working even if allowed to sleep or engage in other pursuits while working. Okay. Whereas if they're working 24 hours or more, they can agree to exclude bona fide sleep time. You're not going to get into a lot of situations like that. You're situations where you have to be there and you can sleep while you're on the premises. If it's less than 24 hours, it's usually going to be covered. If it's more than 24 hours, it may not be. Okay. Yeah.
What if you're working for a business that like it's going to be snowed in and they say, but we need employees to work, tomorrow, so you're going to need to stay the night tonight, like in a hospital or a hotel or something. Would you be paid for that time, or do you just?
I think generally that's really not what it's required for, but I think I think the employee, and it's going to be case by case, it's going to look at the whole situation. I think frequently in that situation, the employee is going to be entitled if they're not allowed to leave the premises. Now, the question will become, here's what I argue if I'm against the hotel, which everybody knows I'm not, right? Let me make that very clear. If I'm against the hotel, I said, hey, you're not going anywhere anyway. I make the argument, I didn't require you to be here. And that's how I would do it. Now, I'd be a little careful about that as an employer, but basically what I would say to avoid paying that time is, listen, you can go home if you want. I just want you here at 9 o'clock in the morning. Okay? And you may say, well, if I'm not here, I lose my job. The employer could do that, all right? And so you may say, I'll tell you what, I'm just going to stay tonight. I think I've got a good argument if I'm not representing, or if I represent the hotel, as to why I shouldn't pay you. Okay? So good question, just going to be fact specific. But the way I get around that is I send you home. Okay? Now, I'm probably not going to be liable for sending you home. That's just the way it goes. But a good question. Sleep time is one of those difficult areas. All right. Then we get into the area. So if they're working And you may see some situations where we ask you to decide whether or not somebody's working. But if they're working, they generally have to be paid minimum wage under the Fair Labor Standards Act. All right? Now, in addition to minimum wage, Fair Labor Standards Act also covers what we call overtime. And what is overtime? Everybody knows what overtime is. Somebody tell me what overtime is.
Over 40 hours a week.
Over 40 hours a week.
If you're not salaried.
If you're not salaried, right? Now, well, if you're not exempt, all right? And I understand exactly what you're saying, Tom, if you're not salaried. But salary is maybe a way of paying somebody, even though they're an hourly employee. Okay? So I want to make that distinction. But you're absolutely right. I understand exactly what you're saying. So, but for the most part, it's more than 40 hours in a work week. Now, what is a work week? A work week is any 7-day, 24-hour consecutive pay period or consecutive time. Erase pay period out of your mind for just a second, okay? A work week is any 7-day, 24-hour period, okay? 168 hours, consecutive 168 hours. That's going to be a work week. Compliance with overtime is determined by the work week regardless of the pay period. All right, say that again. Compliance is determined by the work week regardless of the pay period. And when I say compliance, I'm talking about compliance with the Fair Labor Standards Act. All right? So, give you an example. We may pay somebody, your employer pays, or you work for an employer that pays bi-weekly, okay, or bi-monthly, bi-monthly. All right, so every 2 weeks. The pay period is an 80-hour pay period, all right? Work week 1, the employee works 45 hours. Work week 2, the employee works 35 hours for a total of 80 hours in that pay period. Is that employee entitled to any overtime day?
Yes,
Yes. And why?
because the person worked more than 40 hours in a consecutive week.
Right. They worked more than 40 hours during that one work week. Okay? So as long as they work 40 hours during that one work week, then they're required to be paid overtime for that one work week, even though the second work week they didn't exceed 40 hours or 80 hours for the entire pay period. So overtime is not based on pay period, it is based on work weeks. Okay? Now, let me throw a little monkey wrench in there. Compensatory time. What is compensatory time? Anybody heard of comp time?
Is that like bereavement pay?
Bereavement pay is really funeral, is funeral pay. Melissa?
It's when you may have worked over 40 hours, but you can take your time off. You can have like 5 hours off instead of being paid 5 hours overtime.
Right. Okay. All right. Basically, compensatory time is payment that is allowed, that you're allowed to take instead of money. You take days off. Now, it is really only allowed in the public sector, and that's important. It is only allowed in the public sector. Now, what happens? And do people want comp time instead of overtime?
Depends on the person.
Depends on the person, yeah. But what you'll find is that it adds up after a while, and people like to bank it, okay? And if they don't have policies saying when you're going to quit or when you have to use it or whatever, a lot of public servants want to take that and then take massive amounts of vacation or get paid for it the time they leave, depending upon how the policy is set up. So it can be a negative thing, but it is only allowed for the public sector. Now, having said that, and here's where we get this monkey wrench into overtime. The private sector isn't allowed what is called true comp time, but is allowed rearranging time. And they may have different names for it. Here's where the law's a little iffy and really hasn't been challenged. There's an opinion out there, but it's really not been challenged, and I don't know how the court would come down. But basically, it is allowed, rearrangement time is allowed in the private sector so long as the comp time is taken in the same pay period. All right? Now, let me give you the example on that. And here's why I'm not sure it will ever stand up if it's actually enforced. But the Department of Labor is the one who wrote the opinion to somebody that asked, and as long as they're enforcing the law, they're not going to do anything about it. Now, an employee may challenge that law. But let's go back to our example. You've got a pay period that's 2 weeks. All right? So how many hours in the pay period? Huh? I mean regular, before I have to worry about overtime. 80, okay? All right? Now, really, each week I have to worry about overtime, okay? But under this Department of Labor opinion, we go back 45 hours in the first week, and I tell the employee, you can take off 5 hours if you want this next week, so that they only work 35 hours. Now do I have to pay them overtime? And the answer to that is, you would think so, but the Department of Labor says as long as you use it in the same period, you don't have to. Okay? Now, yeah, listen.
So you still pay them for the full 80 hours, though?
You still pay them for the full 80 hours, you just don't pay them overtime. Now, I will tell you that will depend upon individual states. For instance, Oregon will allow a private employer to take that comp time of 5 hours, but they still require them to pay the overtime for that first 5 hours of overtime. All right. Well, we used the example earlier, and Dave says, "Hey, you have to provide them overtime." Technically, she's absolutely right, and you do, because overtime is based on a work week. However, the Department of Labor may have carved out an exception by an opinion letter that says if you use it in the same pay period, you're okay. And just as an aside, let me give you how these opinion letters work. I'm an employer. I've got a question. I don't want to get crossways with the Department of Labor. So what I do is I say, hey, here's my situation. What can I do? And the Department of Labor says, we'll answer your question. And here you go. Okay? And I'm willing to live by whatever the Department of Labor says. So now I have an opinion letter. These opinion letters get published. And when they are out there, then people use them to determine how the law is going to be. And we talked about the Fair Labor Standard and the Department of Labor's guidance, all right? And so they use that as guidance. Right now, the guidance is if you take it in the same pay period for private sector employees, then generally you don't have to pay the overtime. That caution you on that, because for the most part, overtime is based on work week, not on pay period. Okay?